The broadcast is now starting. All attendees are in listen-only mode.
Hello, I'm the webinar organiser, Louise King. Thank you for joining today's presentation entitled Environmental Policy and Legislation Update. Today's presenters are Howard Dawes, our Senior Environmental Consultant, and Simon Colvin, Partner and National Head of the Environment Team at Weightmans LLP. You have joined today's webinar listening through your computer system by default. If you'd like to use call in using the phone, just locate your audio pane and select Use Telephone. The dial-in information and access code will then be displayed. Additionally, throughout the webinar, if you have any audio problems, if you try that as an alternative, that should work. You can ask questions throughout the webinar using your questions pane. Simply type in your question and click send. At the end of the presentation, we will respond to your questions. If we don't have time to answer all of them, we will answer remaining questions via email after the session. Okay, Howard will introduce the session, so let's get started. And hello, Howard.
Hi, thanks Louise, and good afternoon everybody, just after midday here in the UK. Yes, my name is Howard Dawes, Senior Consultant Environment here at the British Safety Council. I just want to introduce the session by way of a quick overview of where we are in terms of context, really provide context, because obviously there is an event happening tomorrow here in the UK at least, and it's quite interesting in terms of where we are going from policy and legislation point of view. Obviously there are specific issues from in terms of certain departures from the UK, from Europe, and also the wider, broader international context that is also of note. As I start this, my slides have frozen straight away, so I'm just going to exit if I can do that quickly. It's not doing it at all. Let's see if we can get this to where, here we go. Sorry about that. Okay, so just I just wanted to try and set the scene really before handing over to Simon, who probably most people want to listen to and learn from. So the context is we've got a general election coming up tomorrow, and it's an opportunity for us perhaps to consider some potential changes from an environmental policy and legislation point of view. Where are we on the international scene? So from an international perspective, the UK has signed up to the Paris Agreement, which is an overall agreement to reduce carbon emissions, greenhouse gas emissions, and achieve a maximum, I say maximum, so a limit in terms of global warming. What's interesting the last few days or so is that across the pond, shall we say, in the United States, President Trump has finally, I suppose, put his stall out in terms of withdrawing from the Paris Agreement, which is rather disappointing. However, I just saw on some other environmental media that despite the fact that as a country as the United States has withdrawn from the Paris Agreement eventually, what's interesting to see is that some of the states and the actual cities have actually reaffirmed their commitment to carbon reduction and the Paris Agreement. So whilst more broadly the US are not as committed as we would like them to be, perhaps, at least some of the sort of the states are. So that's hopefully more positive. From a UK point of view, again, leading up to the election tomorrow, we've and the current administration, at least, we have an industrial strategy which provides some sort of context from an environmental and an economic point of view. The overall idea that we are still in this transition towards a low carbon economy. However, what's interesting again in terms of some of the recent debates that I've seen on the television and listened to on the radio recently, is that despite the fact that there is this so-called commitment to a reduction in carbon emissions, when I say we, the royal we in terms of the government, have not necessarily agreed any reduction through these carbon budgets. So there is no implementation plan apparently for the existing fourth carbon budget, which was already agreed 23 to 27, and also the fifth carbon budget through to 2032. So is there some contradiction there? Is there the government on the one hand saying we are committed to reducing carbon emissions, and yet there is still lack of clarity in terms of how we might reduce those carbon emissions? looking at some of the manifestos, I don't know whether any of you have actually had an opportunity to do that. It's unfortunately on the news and the media recently, obviously with other events taking place, unfortunately, as fortunate as they are, certainly environment hasn't really featured, I don't think, in any of these sort of televised debates as much. But just for information, some of the parties have made some certain pledges. So for example, the Labour Party have made a commitment to increase renewable energy generation by 6% under them, and increase the amount of zero carbon energy generation by 2030. That also in the context of renationalising, apparently, energy suppliers. So that's a bit interesting developments from them. From a European point of view, obviously, Simon will probably say a few words on this as well, so I don't want to steal any of his thunder whatsoever, but obviously there are implications as well in terms of Brexit when we leave the European Union. How might that impact on our own policy and legislation going forward, and indeed are we actually going to able to achieve a green Brexit, if you like. Again, Simon will probably say a few words around this in terms of process. So at the moment, the Conservatives have proposed a great repeal bill, which will allow for us perhaps to sort of carry on as normal, perhaps business as usual. But what's interesting, some of the commentators that I've seen, as perhaps if through the Great Repeal Bill there might be an opportunity for deregulation. So does that then present a risk to the environment? Perhaps we won't have as much legislation as we have already, and like me, if you are concerned about environmental protection, then perhaps that isn't such a good thing. Other developments, recently the Conservatives published their air quality plan, and you may be aware as well that they're going through the courts because we failed to achieve certain air quality objectives as well. So yeah, are we, I suppose, how committed are we under the Conservatives to improving environmental quality? Overall, the Labour and the Green parties have proposed new legislation in this area. A new Clean Air Act by the Labour Party, and the Liberal Democrats as well have also proposed a new air quality plan. So air quality, interestingly, has been put back on the agenda from an overall environmental point of view. Conservatives have also proposed a 25-year environmental plan. Again, I don't think there's much detail in that, but that's probably not such a bad thing, because it provides some continuity over a longer period, which we actually need probably for environmental and a wider sustainability point of view. And just finally, before handing over to Simon, the Green Party have made other commitments, greater investment in public transport, trying to, again, reference to resource efficiency and reducing emissions. Interesting proposal perhaps in terms of measures to discourage private car ownership. Yeah, perhaps we need some sort of motivation to find alternatives for alternative forms of transport perhaps, and the Lib Dems as well have made other proposals linked to a green transport and other resource efficiency measures. So again, they're looking at perhaps introducing a Zero Waste Act as well, so encourage much more resource efficiency measures within business. So those aren't the highlights in terms of the manifestos and the pledges made so far. Those are just some of the things that I've seen and I've noted, and perhaps provides a bit of context for what Simon's going to say now. So without further ado, I'll hand over to Simon, and be very interested to hear his sort of thoughts and some news on current policy and legislation and going forward. Over to you, Simon.
Okay, thanks very much, Howard. Hopefully everybody can hear me and see my slides. So yeah, Howard, thanks for the introduction. For those who don't know me, I'm a partner at the law firm Weightmans, where I lead the environment team. I've been an environmental lawyer for about 15 years now, so quite some time. And what I wanted to do today was really just share some thoughts with you in terms of, I suppose, what I've termed some macro topics, some of the bigger issues that we're seeing, written about in the press and talked about in different places, and then perhaps some of the sort of more local UK-based developments in terms of case law and bits of legislation that have come through or coming through at the moment. As Howard said, we live in some interesting times at the moment. Brexit, Trump, general election. So there's a lot going on out there. And I suppose at a very high level, I think what we're seeing is that's leading to a bit of a stasis in terms of environmental developments. There's not a huge amount going on because people are, well, for whatever reason, don't want to make announcements, don't want to bring forward developments, so things are pretty much on ice at the moment. But there are certain things happening, and I want to look at those and hopefully share some valuable information with you about those areas. Okay, so what do I want to cover today? I suppose at this macro level, I want to talk about the Brexit white paper and the Great Repeal Bill. There's some interesting information in there and some bits and pieces to share with you. Look at the circular economy package. That's obviously been getting a lot of airtime recently. Some interesting things within that to look at. Howard talked a little bit about air quality. I just want to pick up that baton and talk about that in a bit more detail. Energy and carbon, as ever, that's always on the agenda. And a couple of things in there that I'd like to draw out. And then just a couple of more micro issues, some recent developments in terms of Japanese knotweed and a case around that I thought you might find of interest. You'll all have heard about the Thames Water case, I assume, and the £20 million fine, and a few thoughts on that. Duty of care and waste crime, again, very topical, and a couple of bits to talk to you about there. And then finally, the regulatory growth duty, something that might have gone under quite a few people's radars, but a very important development. I want to tell you why. We'll wrap up with that as our last topic. All right. I think Howard said to me I've got about 30 to 35 minutes, so we'll get cracking. There's a fair amount to get through. So if we start with the Brexit white paper, I suppose just start with a bit of a sort of history lesson and look back, and then look at what we're faced with. So as we all know, 29th of March, Article 50 triggered, notice delivered, 2-year process to negotiate on departure begins. Spanner thrown in the works because general election announced, and those negotiations have been delayed. We're told now we're going to start until the general election's out of the way. 2 years longer if all the EU member states can agree. I think that's very unlikely. So I think we're basically looking at a 2-year window to get all of this done. Until we do leave, we remain a full member and we've got to comply with all of our EU rights and obligations. There's quite a few of those. The numbers in the next bullet point: 12,000 EU regulations, 7,900 statutory instruments and 1,300 acts of parliament all have an element of environmental and EU influence within them. So you can see the size of the task that we're faced with in terms of actually trying to withdraw ourselves from the European Union and the framework that's in place as a result of that. So what does the Great Repeal Bill do? If you've read the white paper, you might know some of this. If you haven't, then this will be news to you. But I'm just going to go through some of the highlights. So the first thing it does is it repeals the European Communities Act 1972. That was the piece of legislation that took us into the European community, and the Great Repeal Bill will take us out. One of the big concerns, I suppose, within business and within government was how do you ensure continuity? How do you provide business with certainty, sort of day before departure, day of departure? And basically what the government has said, they're going to flip and mirror all the existing legislation that we've got at the moment at an EU level, UK level, will remain in place the day before and the day after, so that basically nothing changes. And that's true in terms of directly applicable legislation, which are things that are in place at an EU level that apply to us in the UK without us having an act of parliament or a statutory instrument. And the same is going to be true of things that are directly applicable or apply in the UK in terms of acts of parliament, statutory instruments. All of those things, nothing will change, it will all stay the same. Historic Court of Justice of the European Union decisions will continue to be binding in the same way that decisions of UK courts are binding, and the intention is that those decisions shouldn't be departed from other than extreme circumstances. EU treaty rights are going to be preserved as well. Within certain EU treaties there are rights in relation to the environment, and those are going to be preserved as well. But having said all of that, it's not a perfect approach. This flipping, mirroring idea is going to result in certain gaps and problems, because within the legislation that we've got here in the UK, or that's directly applicable from an EU level, there are references to EU institutions, regimes and systems that obviously aren't going to apply to the UK once we leave. So how do you plug those gaps? What do you do with those areas? Now, the Secretary of State, Andrew Leadsom, has come out and basically said there's about 25 to 33% of EU-derived environmental laws that aren't going to work post-Brexit for the reasons that I've stated. And so how do you plug those gaps, and what do you do? The easiest way to, I think, explain this to you is to maybe give some examples. And in my mind, sort of 3 key areas are, if you look at the REACH regulation, which is looking at the control of hazardous substances, if you look at EU emissions trading, because those people that are emitting large amounts of carbon that participate in an EU-wide trading system, or if you look at the transfrontier shipment of waste, so people that are exporting waste out of the UK to other EU countries, those frameworks, those pieces of legislation all have direct references to EU institutions, EU ways of doing things. And they're not going to work post-Brexit if you just did that flipping mirroring approach. So what we've been told by DEFRA and what the Great Repeal Bill will enable to happen is DEFRA at the moment are working on those sorts of areas and looking at how they plug those gaps. And what we'll see between now and March 2019 are proposals that will come forward from government as to how those gaps are plugged. And I'll need to share that information with you and I. There will be consultations on those areas so that at the point at which we leave, there is a piece of legislation in place to plug that gap. So there's a new statutory instrument or something as part of the Great Repeal Bill that will fill those holes. So what I would say is, after the general election, keep your eyes peeled, because what we're going to see coming forward are notification of areas where those gaps exist and proposals from government in terms of how those gaps need to be plugged. We should have the opportunity to consult on those proposals before they become law at the point at which we leave the European Union. So something to watch out for. The Great Repeal Bill is also going to include powers to implement the departure agreement to reflect the terms agreed with the European Union. But the Great Repeal Bill, I suppose the power is going to be limited. So the idea is the government don't have this sort of broad-ranging ability to introduce lots of new things that they want to introduce. So nothing new per se. It's only about dealing with what we've got and fixing the problems that arise from that. So it's important to remember that point. But what's the departure agreement going to say? I suppose if I'm hedging my bets, I think it's going to fall into one of two areas. I think either we're not going to have an agreement because the 2 years runs out and we won't have reached agreement, therefore there won't be one, and there's nothing to implement at that point. We will leave, and that will have to be something that's swept up at a later point in time. Alternatively, I think there's a real possibility that as part of the negotiations to leave, we'll actually agree to exceed and continue to observe and comply with EU environmental legislation. Why do I think that's a distinct possibility? Well, if you actually look at what the European Free Trade Agreement actually says, and to be a member of the European Economic Area, which is countries like Norway, and that's also one of the options that's open to us, but it's not palatable because all the things that come with it in terms of free movement of people and the like. One of the things that is required as part of that approach is that those countries, such as Norway, agree to abide by all EU environmental law, but have no influence over it. So it continues to apply to them, but they have no say. In my mind, to date, we've seen, I suppose, the environmental arena features so little in terms of discussion and debate around Brexit in the general election. I think there's a real chance that at the point at which we leave, or as part of negotiations, the UK government will turn around and say, look, that's an easy gift for us. We'll continue to comply with the EU environmental laws. They'll make that concession partway through the process. I suppose at least then we'll have certainty in terms of what we've got to deal with and what we're going to face. But the real downside from that is we lose the ability to influence EU environmental law directly because we're no longer part of that group. We're not involved in the legislative process, and we almost have to accept what we're given. So that would be a real downside to that. But I think, in my mind, that's a distinct possibility. All right, so that's enough about Brexit. What I want to do is just move on to look at some of the other, I suppose, what I've termed macro topics. The first of which is the circular economy package. I'm assuming everybody's heard about this. If you haven't, where have you been hiding? There's a very simple diagram on the slide there which basically sets out what the change is. It's this idea that you move from what's termed a linear economy at the top there to a circular economy, and in doing so you capture valuable resource and generate money from doing that. And various figures banded around from this, but globally people talk about trillions of pounds. At an EU level, people talk about billions. So if you listen to perceived wisdom around this, it could be very, very valuable. But this is now widely accepted as the next phase in the development of environmental policy, certainly at an EU level, and it's definitely catching on in the UK, certainly in the devolved jurisdictions. I think England will follow. So what's the history to the circular economy package? So the package that we've got now was published in December 2015. I've said that was round 2 because we had the first package published the year before, but that was not back. Said to be too ambitious, people didn't like it. So we've got this new package, which basically sets around 4 new legislative proposals focusing on waste generally, packaging, landfill and WEEE, so waste electrical and electronic equipment. And the idea is basically to improve waste management practices in line with the waste hierarchy. It's the idea that you prevent, minimise, reuse, recycle. look at energy recovery, and then disposal as a last resort. And it's basically a view that we're starting to come up against a bit of a glass ceiling in terms of the way in which we deal with products and the way in which we deal with waste, and we need to move to that next stage, and the circular economy is the answer. It's basically that long-term vision. It's a strategy to guide investment. We all know that if people are going to put money into things, they need to know the direction of travel, and this is very much said to be the answer. Oh, slightly strange graphics going on there. Okay, so what is the package? What's it comprised of at the moment? So basically there's some revised EU targets for recycling of municipal waste, 70% as an 80% target for packaging waste, and there's going to be a new binding target to reduce landfill to a maximum of 10% of total waste by 2030. So some pretty stretching targets in there. Where are we up to at the moment in terms of this process? Most recent reports was what are called these trilogue negotiations between the European Commission, European Parliament and European Council, and those started last week. The expectation is very much that those will be ongoing for probably sort of the latter half of 2017, but we might see some certainty come from that in terms of facts and figures early next year. And basically what you've got, the European Parliament pushing for some high numbers and the European Council pushing for some low numbers. That's primarily because the European Council represents the member state governments more directly, and obviously they're looking at the impact that this is going to have and how they can deliver those targets and the costs. So, they've already come out and said, well, they'd rather see a 60% target for 2030 as opposed to the 70% target. So I'm sure there'll be some horse trading around this, and we'll end up with some figures in the middle of all of that. But again, we'll come back to Brexit, and what impact is that going to have? Because when you look at timescales, and I've just talked about these negotiations which have just started, if they're going to run for the second half of 2017, we may be looking at some figures and being announced the early part of next year, maybe some legislative proposals put on the table next year. If we get a directive, though, there are always those implementation deadlines that come forward, and there's usually a period of time within which member states will implement those new targets, those new bits of legislation. And I suppose the interesting thing is going to be the point at which any new directive is brought forward, and the point at which those new targets actually bite. Because if you think back to what I said about the Great Repeal Bill, it's going to make sure that any legislation that applies is flipped and mirrored and applies to the UK from the point of departure. So if the European Union get a move on and move all these things through, we might actually find ourselves in a position of actually being bound by the package that's introduced by the Union. If I'm honest, I'm not sure that will happen. I've just got a feeling that perhaps we'll miss that. It won't apply to us. We'll end up having to do our own thing, but you never know. Time will tell. If we don't have a circular economy package, what are we going to have? Well, if you look around at the moment, certainly within the industry, and you talk to local authorities as well, who've got a large part in delivering a number of these areas. Industry, keen on energy from waste at the moment. A lot of these large energy from waste plants going up around the country, and some smaller scale plants coming forward as well. They're very keen on that, and I think that would definitely be part of the solution that the government would bring forward. But then when you put that back against the waste hierarchy, it falls quite some way down. So, are we really aiming high enough in terms of what we want to achieve and what our expectations are? There's then this idea of extended producer responsibility schemes. You speak to local authorities who, have responsibility for collecting household waste and then dealing with it. Really strapped for cash in terms of what they can deliver. You might see in the press a number of these large waste PFI projects are starting to fall by the wayside. And I suppose local authorities are saying now, look, we need more money to be able to deliver these things, which we can actually handle these materials. And introducing extended producer responsibility schemes is thought to be one way of doing that. So basically pass the cost back to the producer of these products. Inevitably it comes back to consumers, you and I, but somebody's got to pay for it. Government doesn't want to have to do it through a direct tax themselves. They'd rather it's done by the back door, if you like. So that's likely to be something we get to see. Howard touched on some of the strategies and the policies. At the moment we're in a policy vacuum. Up until sort of Brexit, governments have been happy to ride on coattails of the European Union in terms of environmental policy, things like the 7th Environmental Action Protocol. There was a good direction of travel at European level. You could see what was coming. You could know when and what's going to happen. We drop out of that and we're into a vacuum because the government won't announce any policies at the moment for various reasons, general elections, Brexit. They don't want to undermine their position, they tell us. So we're in a bit of a black hole in terms of knowing where we're up to. And I suppose, again, my view on this would be, are we going to see any new UK initiatives until post-Brexit? Maybe not. Maybe government says, no, we can't undermine our negotiating position from a Brexit point of view. But, if we see the Conservatives come forward with a large majority after tomorrow, maybe they'll be a bit more bullish. Maybe we'll see a bit more direction from them, but I wouldn't bet on it. Okay, air quality. Another macro topic. Howard's mentioned it briefly as well. So it's been in the news a lot. Lots been said about air quality. We've had lots said about the air quality plans. Where's this all coming from? Well, you've got a directive from 2008 that set out a number of requirements in terms of ambient air quality. And it set out and prescribed limit values for certain substances. Needless to say, UK, a number of other member states did not meet the necessary requirements in terms of those limit values, and I'll give you some example of those in the next slide. And so basically now we've got infraction proceedings ongoing by the European Commission and the Court of Justice of the European Union against a number of member states, including the UK. What I would say, though, in terms of the UK, they seem to be on hold at the moment, pending the outcome of this ongoing litigation that we're seeing with Client Earth, and I'll delve into that in a bit more detail in a second. Just to highlight some of the limits you can see here for nitrogen dioxide, NO2 and PM particulate matter, you can see what some of these limits are. I think the interesting column for me is looking at the compliance deadlines, and you can see that there's some pretty strict deadlines in terms of when these limits should have been met. But then actually when you look, there's the ability to have extensions to certain points in time, so 2015, 2011. But those are on the basis that plans were submitted setting out how member states were going to achieve those limits. And that's really what we've seen in the UK. The government was very late, didn't meet the initial deadlines, was very late in putting forward its plans, and the plans that have come forward have been deficient. And that's why we've seen this, I suppose, this trail of litigation with Client Earth, which I'll just run you through now. Okay, so what's the history to all of this? So 29th of April 2015, Supreme Court orders DEFRA to develop a revised air quality plan, basically told that their initial attempt was inadequate. So you get to December 2015, revised plan published. Roll forward nearly 12 months, plan quashed, government told to issue another plan, this time by April of this year for consultation, and the plan is due to be finalised by the end of July. Get to April, government getting a bit nervous about upcoming general election. I've got some sympathy for them actually, because I think maybe they could have been more bolder in a plan if they'd been given more time. But you can see that actually having some bold intentions within this plan would not have been a vote winner. And so actually, have we ended up with something that's just watered down, not aimed at not being a vote loser, and that sort of gets to the point we're at now. Because what we had was a government plan that was widely criticised by a number of people, basically passing the buck on to local authorities and not really, didn't have any teeth, didn't really set out to achieve anything. And lo and behold, what we've seen just in the last week or two is Client Earth coming back saying, actually, we're now ready to launch a further legal challenge because we still think this plan is deficient. You've not gone far enough, government. You need to do more. So that brings us up to the present time. So what's going to happen next in terms of air quality? Well, the consultation closes next week, in June. I think it's next week, yeah, next week. As we said, the revised plan is due to be published at the end of July. We've had Client Earth posturing, I suppose is the way I see it, and talking about a further challenge. And I think what they're basically saying is, look, if whatever comes out of this process is not bullish enough, then we will challenge you further. I think, and I said this previously about another point, that if after tomorrow you've got a Conservative government, I think that's generally accepted that's going to happen when you look at the polls, but we all know polls could be wrong, but assuming that happens, I think we could see a new strengthened plan come forwards. And I wouldn't be surprised if it did, but obviously let's get tomorrow out of the way and see what happens. What will the role of the Court of Justice of the European Union be, and what will the impact of Brexit be on all of this? It's going to be very, very interesting because, again, I think a lot of it comes down to timing, doesn't it? But if the UK can come forward with an adequate plan in the near future, then the likelihood is that actually the role of the Court of Justice of the European Union will minimise. They won't need to take any part in any infraction proceedings. There'll be no impact from that. Impact of Brexit. Well, again, we've talked about the fact that the existing directive is going to be mirrored and implemented in UK law, so that will continue to apply, so will those limits. So perhaps some minimal impact there. What about some of the practical things that we're going to see? Well, talk about diesel cars, vehicle emissions, going to be a big impact there, and the expectation is that over time we'll see some more strengthened proposals come through in terms of a scrappage scheme for diesel cars, the use of diesel cars, thinking about some of the activities that you might be involved in, whether it would be for construction companies or on development sites, the role of generators and their use, permitted activities, other infrastructure projects, the new Heathrow expansion project. As a firm, we're involved in some new road expansion schemes at the moment and looking at the impact of that in terms of air quality. All of these things are going to be caught up in that process, and I think it's going to be a lot more difficult to try and squeeze those things through in the future as this becomes more of a hot topic. Okay, next to my macro topics is just to talk about energy and carbon and Paris and beyond, and I know Howard touched on this as well, but just a bit more detail for you around this. So Paris agreement was signed and ratified by the UK, but I think it's interesting to look at how that was done and the UK's role in it. So people may recall that the way the Paris Agreement works is that each country has a national defined contribution, and the idea is that's their contribution to achieve this 2 degrees C target by 2020, and then further contributions are made 5-year intervals after 2020. Well, what we did as the UK was to submit a joint NDC with the European Union, and the way that then works is there are negotiations and discussions at an EU level as to what the UK allocation is going to be as part of that. That's ongoing, that's not been finished, so we don't know. And that gives rise to the question of what is the impact of Brexit on that, because there are two options. Once we leave, we can either continue as part of the EU team up to 2020, beyond if we wanted to, or we can submit our own NDC. But that point about no backsliding is that the way the agreement is set up is that you're not allowed to go backwards, you always have to go forwards. So if we did leave and submit our own NDC, it would have to be something that built upon what we've committed to so far. So no stepping backwards, if you like. So what have we got in the UK at the moment? Well, we've got a greenhouse gas reduction target of 57% by 2030, and that's pursuant to the fifth carbon budget under the Climate Change Act 2008. Important to note that at an EU level, they've only committed to a 40% reduction by 2030 against the baseline level. So we're ahead of them there, but, and again, Howard alluded to this, is that we've got a massive policy gap. Because at the moment, the current policies we've got only deliver 50% of the necessary reductions. So we've got nothing to deliver the fourth and fifth carbon budgets. That's a big problem. We were meant to have the emissions reduction plan this year, but Brexit, general election, again thrown a spanner in the works there. We're told that it would come after the general election, but again, we're going to have to see some pretty imaginative policies that are going to be able to drive us forward to achieve those targets. Progress is being made, but we're going to have to see something pretty drastic if we're going to reach that point. So again, watch this space in terms of that plan, which is expected later this year. And again, Howard talked about, I suppose, the impact of the US departure. Really interesting, I think. I think the announcement by the mayors of various US cities and the response of a lot of large US corporations, in my mind, indicates we perhaps reached a tipping point with all of this, whereby it's almost become bigger than a country, it's become bigger than the government, and actually, just the will of people and the will of companies is going to take on the mantle of these sorts of things. And the other thing I'd say is, well, Donald Trump's got 3 years left. Will he get it again? I don't know, but personally, I'm counting the days. But it will take, if the US do want to leave, depart the sort of Paris agreements, it's been reported it will take them 4 years to do that. So I think there's 3 years, they have to give 3 years notice, and there's a year's process to extract themselves. And so actually, the point at which they leave and give notice would coincide with the next US election. And so query whether it would actually happen anyway. If they have the election, will the next president want to do that? When you look at what's going on in the, I suppose, the public arena in the States, perhaps not. But again, I suppose quite hard to tell with a lot of things these days. But yeah, I'd like to think that it wouldn't happen. And actually, it's just bad PR for the States at the moment, and actually it wouldn't leave when push comes to shove. All right, so get down into a bit more of the sort of the micro stuff now, in terms of looking at some of the specific developments, specific bits of legislation, things that are going on in the UK. So everybody, or hopefully everybody's heard of the Carbon Reduction Commitment Scheme, which came out in 2010. introduced pursuant to the Climate Change Act 2008. One of the ways in which the UK is going to achieve these greenhouse gas reduction targets that were set out. Big problem with it is it's going to be scrapped in 2019. It's been problematic ever since it was introduced. I remember looking at a lot of detail sort of 2008 onwards as it was coming through. Really, really complicated. People spend a lot of time and money looking at it, implementing it. Needless to say, government are not going to scrap it because it's been such a pain. Now, Energy Saving Opportunity Scheme 2014 came in pursuant to the Energy Efficiency Directive 2012, and the idea was that we were going to lose the CRC scheme. We were going to have a new regime which was based around ESOS. That was going to happen because ESOS was derived from the European piece of legislation, and that's something we couldn't get rid of at the time. But obviously now we've got Brexit, the position is very, very different. We will have that, if you like, that mirror flipping of legislation that's already in place. The Energy Efficiency Directive will stand, but there will be more latitude and more flexibility for the government to do what they want to do. So we may see a different approach from 2019 onwards. From the government's point of view, really what they need to do is fill the hole that's going to be left in the Treasury's pocket, because at the moment CRC generates about £1 billion. But what's it going to look like? What's it going to be? What they're talking about is a single carbon pricing and tax system. So basically, price carbon, depending on how much you use, calculate it, pay a tax. Relatively simple. And if you're doing things to try and reduce your emissions, you've got plans in place, you've got commitments there, then there'll be some sort of reduction or exemption from that. But again, we're not seeing any of the detail come through in respect of that, and that's what we really need. We need the detail to understand what's going to happen. I think what I'd say is that the framework's there. We've talked about the Paris Agreement, we've talked about the Climate Change Act. You've got the carbon budgets. What we really, really are missing is the policy and then the tools to actually implement it. And I think that's what we're going to see in the next 12 to 18, 24 months, get some more certainty around that as to how these things are going to happen. Elephant in the room at the moment in this area is certainly the EU emissions trading scheme. Does that go? Does that stay? Interesting to note that the European Union system is actually based on an earlier UK system that we had in terms of emission trading. So we've done it ourselves before, we probably do it ourselves again. If you look at investors and a lot of the commentary on this, people are asking that there's some sort of managed exit from the EU ETS if that is the approach. So if we leave Brexit and we don't agree to concede by environmental law and we leave the EU emissions trading scheme, they're asking for a managed exit over a period of time that perhaps coincides with the different rounds that you've got in terms of EU ETS. If I remember correctly, I think one of the next rounds is up in 2020. So if we do leave and we leave everything behind, then what you might see is a managed exit up to that point, at which point we leave, we go and do our own thing. But again, it will depend what happens in terms of negotiations. All right, completely changing tack, so moving away from energy and carbon to look at Japanese knotweed. So we had the EU Invasive Species regulations. That's a directly applicable piece of EU legislation that came through in 2014, introducing some new requirements in relation to invasive species, basically putting in place a more proactive approach to these sorts of problems. What we previously had in the UK was a reactive approach under the Wildlife and Countryside Act. If somebody did something in relation to an invasive species, then the appropriate regulators could go and prosecute them. But that was very reactive, and if I'm honest, action pursuant to that in terms of these things was very, very rare. What we now have, pursuant to the Infrastructure Act 2015, is a proactive approach in relation to what are called INS, so invasive non-native species. And the approach that we're going to see come forward is you're going to have these species control agreements and species control orders, so SCA and SCOs. And the idea being that regulators will identify areas that are impacted by invasive species. They will approach people who are responsible for the land on which those are based, encourage them to enter into an agreement that will provide for the management of that invasive species. If that third party will not engage and won't cooperate, then it's open to the regulators to actually issue these species control orders, whereby the third party is required to do the work. If they don't, regulator can do it themselves, recover costs from third party. At the moment, there's guidance that's needed to make all of this work, and that's not been brought forward as yet, so we're still waiting for that to happen. But as and when guidance comes through, we will see these starting to be rolled out. So if you are a landowner and you've got sites affected by knotweed, then be alive to this, or if you've got sites that are impacted by knotweed from elsewhere, again, be alive to this. And then finally, just to pick up on this idea of third-party claims, there was a case recently involving Network Rail. If you're on a train, you look out the window in the summer, you probably see Japanese knotweed along railway embankments. It's very, very common. Excuse me, I'll take a sip of water. Very, very common, and it was used, I understand, by sort of predecessors to Network Rail to stabilise railway embankments. The problem they've now got is the growth is completely out of control. A couple of chaps down in Wales brought a case against Network Rail because knotweed was basically growing up into their back gardens and impacting on their ability to sell their properties. We understand that what's happened up to this date is Network Rail always sought to settle cases out of court, but that was getting quite expensive. They wanted to test cases to see what the extent of their responsibility was. One of Network Rail's arguments in the case was that you can't impose liability on us because it'd be too great. You know, the cost of having to deal with this is just too significant, and therefore, you know, that's not appropriate. The court said no, you are responsible. A, you're responsible for the cost of treatment, and B, responsible for the reduction in value of the property. What the court said was that they're not responsible for the whole of the reduction in the value of the property, because there's a possibility that actually the knotweed can be treated and therefore you can't compensate people too far. But what the court said is that if the treatment isn't successful and doesn't work, the claimants could come back and ask for more money. So this is established, if you like, a baseline against which people can now bring claims in respect of these sorts of issues. And again, if you've got land that has knotweed on it, be alive to the fact that it could be impacting others and you could face these sorts of claims. It won't be long before you've got knotweed chasing firms out there pursuing these sorts of claims. Equally, if you've got land that's impacted by knotweed from another site, you know, again, it's an opportunity for you to perhaps use that to your advantage. So be aware of what the opportunities are and what's on your land holdings. Okay, Thames Water and the £20 million case, which was before the courts not so long ago. People recall we've now got a Sentencing Council guideline for environmental offences. There's also a guideline for health and safety offences as well. It all works around this idea of tables that relate to the size of company, and depending on the size of company you are and how bad you've been, how significant an offence is, and the incidence of that offence, the impact of that offence is, and that incident, you go to a table, it gives you a number, and you get the resulting fine. What we saw with Thames was, I suppose, what's said to be the highest fine we've seen to date in relation to environmental incidents. The total fine was £20.3 million, and that included £600,000 of environmental agency costs. So a lot of money, big headlines. When you break it down a little bit, there's a bit more to it than that. It actually related to 21 incidents across a number of sites. In terms of strategy, I don't know whether Thames Water thought we'd roll all of these things up into one case and get it all dealt with at once, whether it was their decision or not. But there are a number of incidents involved in that, different fine levels associated with each of those. But if you average them out, it was probably just shy of £1 million per incident per offence. Thames were punished because they've got a history of offending. Much like other utility companies, they operate in a very sensitive environment. Things do go wrong. There are environmental incidents. There are impacts as a result of that, and therefore they do have a history of offending. The court here was absolutely sort of bent on making sure that the message was sent home to the shareholders. Thames had been before the courts previously, and this point had been made, and there was a feeling in this case that perhaps it would seem to be cheaper to offend than it actually was to comply. And in this case, the judge decided that actually, no, we're going to go for a very big number here on the basis we need to take that message home to the shareholders, the directors, and get them to change their approach. The £20.3 million fine was said to be equivalent to 2 weeks of Thames profit. So, you know, different views on that, but it's still a significant amount of money. Key messages for me from this case are, it's worth reading the judgment because there's some good stuff in there in terms of things that other people can take away to their businesses and how you can learn from things, the mistakes that Thames made, and make sure that your company doesn't, I suppose, make those same mistakes. But learn lessons. So if things do go wrong, make sure you rectify those things so that you don't find yourself in the same position with the same set of facts and circumstances, because the court take a very dim view. Make sure you've got the owners of the company and the board of directors engaged in environmental compliance. Make sure there's a link between the people on the ground and the people at the top in terms of what's going on, decision-making process. And adapt your systems. This is a really easy one. If people have got instant response protocols, make sure that your approach, the language that you're using, reflects what these guidelines say. Very, very simple, real easy win for companies and businesses. It just means that if something does go wrong, you're automatically following the process that the courts and the regulators are going to be looking at in terms of how they approach things. So make sure you do the same. Right, duty of care and waste crime. Waste crime, huge issue at the moment. Again, you can't get away from it if you're reading sort of trade press, picking up newspapers, all sorts of things going on across the country with illegal waste sites. Government pumping money into the Environment Agency to focus on these problems at the moment. What we haven't seen to date is, I suppose, the bold use in my mind of the duty of care, which is provided for under Section 34 of the Environmental Protection Act 1990. Very sort of high level, duty requires people to take all reasonable steps to do those things that are listed on the slide. I'm not going to go through them line by line, you can read them yourselves. The question I always end up in with, you know, sort of contacts and clients is actually how far do you go though? Because the government guidance this area used to be a helpful-ish document that was about 30 or 40 pages long. That was revised relatively recently and it's now down to something that's much shorter. And so actually it's very difficult for businesses and companies to decide how do they actually comply with the duty themselves, how far do they go? You know, do you have to go and visit all of the sites that, you know, material that you dispose of is going to? Do you have to follow every load that leaves your site? If you don't, how many loads do you audit? What is the extent of your audit process in terms of those, you know, those operators and those companies? What I would say is we're seeing an increased level of prosecution and scrutiny from the Environment Agency in terms of breaches of the duty. They're now recognising that actually this is an important tool for them in their ability to combat waste crime. And so actually they're being a lot hotter on this and expecting a lot more of people. We're acting for a couple of clients at the moment who are being prosecuted for breaching duty of care. And you look at the sort of the steps that the regulators are expecting them to take, they're asking them to go quite a long way. You know, you've got to be very, very clear, for example, if you're taking material to a site on the terms of their exemptions, what do their permits allow them to do, what are the volumes, what are the types of material. You need to be visiting sites, you need to be auditing paperwork, you know, you need to be speaking to the regulators. Do the regulators have concern about sites, you know, that you're going to be trading with? You need to be thinking about all of those things, because if you don't, you take material to a site, something happens at that site, illegal operations, maybe that company shuts down, maybe they do something they shouldn't do, that can work its way back to you if you should have done things, and if you'd done those things, you could have identified those problems at that site. So something to be very careful of. And what I would also say is that there's a waste crime white paper that was due out in the spring, but obviously we've got the general election, so nothing coming from government at the moment, but expected in the second half of the year. Waste crime is said to cost the economy over £600 million, a lot of money, and the government are looking at ways of addressing this. And so the greater enforcement of the duty of care is one way, but there's other things being talked about in terms of proportionate responsibility for waste on illegal sites and those sorts of things. So again, it's probably worth revisiting, you know, the arrangements within your company in terms of waste disposal to make sure that, you know, you're crystal clear in terms of who's doing what, where things are going, and are the people you're dealing with, are they authorised to do what they do, and are they doing it properly? Are they doing what they're telling you? Because taking things at face value is not enough. All right, I'm conscious I'm running up against my my deadline in terms of timing, so this is my last topic. Regulatory growth duty. The legislation this is derived from was, as it says in the slide, came out back in 2015, but it didn't come into force because there was a guidance document that needed to accompany it, and it took a while to agree what that guidance was going to say. The regulatory growth duty, I think, is a hugely important development. It sits alongside something called the Regulators Code. And these are basically the rules of the game, if you like. These are the things that regulators need to abide by when they're dealing with companies, when they're making decisions about what they require you to do, whether it be in terms of reporting, whether it be a whole host and range of things. You need to know about the regulatory growth duty. You need to know about the regulators' codes, so that you've got them in your pockets as part of your armoury. Because if the regulators are asking you to do things which are perhaps aren't practicable, they're unrealistic, they've not thought about the cost consequences of what they're asking you to do, which does happen. You know, I think regulators can sometimes be a bit blinkered in their approach, and they just ask for things without thinking about what it actually means for a company. These are the sorts of things you can go back to them with. Clients and contacts often say to me, Simon, well, look, we've been asked to do this by the regulator. It's going to cost us a load of money. We think it's completely unfair and unnecessary. How do we push back? And quite often it's difficult because there isn't really a full mechanism against those sorts of decisions. Either you challenge it by way of, say, judicial review, but that can be very expensive and time costly, expensive, people don't want to do that. Or you continue doing what you're doing, that leads to a breach of environmental law, you invite enforcement and then you challenge it through that route, but that's a very risky strategy because people don't want to go down that route. Now with the regulatory growth duty and the regulators code, I think there's becoming more of a peg on which to hang, I suppose, arguments and disagreements with the regulator's approach. And you can actually use the duty and the code to push back and ask regulators to justify their decisions, to justify their approaches. So if we just flick through some of the highlights on the slides here before I finish, when exercising regulatory function, must have regard to promotion of economic growth, ensure regulatory action only taken when needed is proportionate. The guidance regulators say they've got to have regard to growth because it's an important factor. They've got to be transparent and accountable in relation to the role of the duty in the decision making. So you can ask them how it feeds into what the decision's been. Important to say it only applies up to a certain point. So once they've decided to instigate criminal enforcement proceedings, if that's the route they're going down, it no longer applies, but it applies up to that point. I think, as we all know, there's a significant period before things reach that point of seriousness where you're looking at sort of compliance issues, and that's why this is so valuable. Regulators need to think about how their approach could have an adverse impact on a business, on a company, and think about actually how they could change their approach to lessen that impact. But really come back to these three primary areas. It's about minimising the burden, it's about a proportionate approach, and the need for understanding, so you can push for those things. Just in terms of this last slide, some absolute pearls in here for people to use. But I suppose the practical interpretation of the duty of regulators, as per their own guidance, says they've got to be clear about things, in terms of what's required to achieve compliance. What we know at the moment with the regulators, because of the funding problems they face, a typical response is, well, okay, you don't like what I'm putting forward, Mr. Regulator, what should I do? A response that typically comes back is, actually, it's not for me to tell you. Well, if that's a regulator's approach, you can reel the duty back to them. Use of reasonable timescales, again, regulators not greatest at coming back on occasion. Use the duty to sort of push them to be more responsive. Use of best intervention to achieve compliance. So EAR, repeat visits to a site, the best way to achieve something is taking up people's time. The best way to achieve something are there other means. And again, the need to communicate decisions clearly and promptly. So one practical tip from all of this in the regulator's code, which you can access on the .gov.uk website, is just use these things to sort of gently prod and probe and challenge regulators if they're asking you to do things that you don't agree with and you think are unreasonable and unnecessary. Get them to justify their approach and their position using I suppose these things, and you should get some traction because they're required to actually take account of these different bits and pieces. But that's enough for me. I think I've slightly overrun my slot, so I'll hand you back to Louise. And I think we've got some questions which we're now going to take from the audience. So thank you.
Hi, that's great. Thank you. So we do have a few questions, and the first is from Joe. Joe has said, in the context of Brexit, will the UK be able to participate in any EU consultations on environmental law, as and when we leave the EU? For you, Simon.
So, I was going to pass that one to Howard, actually. So, from my point of view, I suppose it depends what happens in terms of Brexit. So if we leave and we leave everything behind, then obviously we're not impacted by EU legislation. The wisdom is that's very unlikely to happen. There will be some sort of strings attached in terms of, just as simply as trading with Europe, we'll need to comply with things like REACH obligations and other producer responsibility type schemes in terms of marking arrangements and those sorts of things. So if you assume that we are going to have to play by some of the rules, but we're no longer part of the team, we won't have a formal ability to influence those bits of legislation because there just won't be a mechanism for that to happen. But what I would say is that I think there's two ways which we would try and influence those rules, which would be lobbying. There's nothing to say that we couldn't try and lobby the EU institutions. And the other way would be through member states as well. There's nothing to say that we couldn't go to member states that we have good relationships with and work with them to try and achieve changes that perhaps suited the UK. But they could put forward those proposals sort of, as their own, if you like. Because, I mean, if you look back, the UK has always been recognised as one of the greatest influences of certainly environmental policy and legislation that comes from Europe, in a positive way, I understand. in that, we've got engaged and we've tried to sort of change things for the better. So I think we will always have some sort of role in terms of influencing the roles that apply to us. It might not be a formal route, but there will be some way and means of doing that.
Great, thank you. Okay, I have another Brexit question from Gregory. Do you think that Brexit will lead to the UK becoming the dirty man of Europe from an environmental perspective?
So I think this question is about the sort of the race to the bottom, and will we just see, if we say Theresa May and the Conservative government once we're out, just doing away with a lot of environmental control legislation, and it just becomes a bit of a free-for-all? I'd say no. I don't think that will happen. And I think the US example is a good one. There you've got Donald Trump now, who's saying, look, I'm going to pull out the Paris Agreement, I'm going to do all these different things. But then you actually look at the reaction of, big business, you look at the reaction of the mayors across all of the different cities actually saying, no, well, we disagree with you, and making him look a bit stupid. And I think he's underestimated the swell of public opinion in terms of these sorts of issues. And I think that would apply equally in the UK. And so I don't think we would see a race to the bottom. I know as part of Brexit, a lot of people thought, well, actually, this is an opportunity to try and rewrite environmental law and come up with a much better system. I would have thought that was a bit optimistic. I didn't think that was going to happen. I think what we'll see post-Brexit is perhaps more of a reactive approach to environmental policy and legislation, certainly in the early years, because the government will be dealing with what they perceive to be other bigger issues. I think in the longer term, we might be able to come up with a better system way of doing things. But I just don't see it being a race to the bottom. I just don't think people would accept that. I don't think it would happen.
Okay, thank you.
If I could just chip in there, I think as well, I think from, as Simon alluded to, I think the UK has also taken a lead as well in terms of developing policy legislation that has then evolved and been adopted by Europe. So I don't think the UK will become necessarily the dirty man of Europe going forward. I think we'd like to think, and this is Howard speaking now, being ever an optimist, being sort of lead by example, and I would hope to think, post-election tomorrow we will continue to do so.
Great, thank you. That is all the questions we have so far, but if anyone does think of any further questions, please email them to webinar@britsafe.org, and I'm sure Simon and Howard will be happy to answer. Thank you very much to everyone listening, and thank you so much to Simon and to Howard for presenting today. Have a lovely afternoon, everyone, and goodbye. Thank you.